Will directors be held personally liable if the business is dissolved? Directors of a business typically do not have personal liability for the actions that they take in their business in good faith. However, you can take legal action against directors if they breach one of their duties or if they are personally negligent. And that personal negligence depends on the kind of business a little bit. A doctor can be sued for professional malpractice, which is negligence. Here is an example of a situation where a director can be personally liable, and that is the breach of a fiduciary duty. So if you are one of the people in charge of the business, you are responsible for making sure that you do not have a conflict. You can't usually be a director of two competing companies. So there are some cases where directors can be personally liable, but typically if you have an LLC or a corporation and it has been formed and managed properly, the maximum liability is whatever money they have invested in the business. So if you spend $50,000 starting a business and it fails, you're going to lose that $50,000 and that's it. However, we commonly see people do things that weakens the protection of that wall between their business risks and their personal assets. And that is called piercing the corporate veil. And that does happen. Oftentimes, again, when a leader of a company breaches a duty, that's a really good way to weaken the wall of protection. But normally, if you've done things right, then directors are not personally liable, even if the business is dissolved. Hit the subscribe or follow button so that you get notified. We do this every 2 weeks on Friday. The end.